Oyez, oyez, oyez. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Well, good morning, everyone. Good morning. Welcome to the 4th Court of Appeals. As you know, the COVID-19 pandemic has prevented the Courts of Appeals from holding in-person oral arguments at this time. And so this court is holding this oral argument on Zoom platform. And because this is new to us, if there's any technical difficulties while we're conducting this hearing, we will take a break, and you will, when we resume and reconnect, we will pick up where you left off. You'll have the time remaining on the clock. Also, you may be aware that on May 8th, the Texas appellate courts, most of them, including the 4th Court of Appeals, were victims of a ransomware attack, which brought down the network. But I want you to be assured that we have before us the entire record in this case, the briefing, the clerk's record, and all of the court reporter's records, save and except one. We are missing volume 11. We have all the other volumes, but we are missing volume 11. And so we would ask that that counsel discuss with one another following today's argument or sometime before the end of the week, whether or not either of you have volume 11, and if one of you could please contact the clerk of our court to get the Dropbox information so that it can be emailed into a Dropbox here. Again, that is just volume 11. We have everything else. Are there any questions on that?
No, I think I have volume 11 in electronic form, but I'll have to check.
Very good. Well, we would appreciate one of you sending that to us through our Dropbox. So thank you for doing that. And finally, just a housekeeping matter, the judges have decided that we will raise our hand when we have a question. So that's your cue to stop to stop talking and to allow us to ask the questions that we have of you today. So let me start with taking your announcements. First, of course, this is Lee B. Wheeler, trustee of the LMP Children's Trust, and Nancy Wheeler Plumley versus San Miguel Electric Co-op. So for the appellant.
My name is Dwayne McWilliams, and I'm an attorney in George West, Texas, and I represent the appellants, Lee B. Wheeler, trustee, and Nancy Plumley, and we're here and ready. And this is the first one I've done, so I hope it all goes well like this.
Well, we're only one ahead of you, okay? So this is our second, so we'll all get through this together. All right, and for the appellee?
Your Honors, Melanie Fry for the Appellee, San Miguel Electric Cooperative, Inc.
All right, and I assume you're ready as well, Ms. Fry.
I'm ready.
All right, well, as you both probably know, you each have 20 minutes to make your respective arguments, and then Mr. McWilliams, you will have 10 minutes for rebuttal on behalf of the appellant. And with that, I am going to mute myself, and Mr. McWilliams, you may.
And excuse me, I'm suffering from sinus today. I'm a sinus sufferer, so I may be, my voice may come and go. I think it's important to really understand this case, and I understand y'all have read the record, to give a basic sketch of the facts of this case. In 1954, a coal lease was executed by Clifton Wheeler and Nora Wheeler, covering approximately 2,222 acres of land in McMillan County. That coal lease was amended in 1975. Clifton and Nora Wheeler are both now deceased. Both of their wills were dated April 3rd of 1981. We think that's important because of the construction of the deed on the granting of the summary judgment. Clifton Wheeler died in 1981 and Nora Wheeler died in 1983. After that, the property basically passed to, they had 3 children. One was Charles Wheeler, who predeceased his parents. Clifton Wheeler Jr. and Evelyn Wheeler Swenson. Each of those people got a third of the estate, except that the children of Charles Wheeler got a ninth each. In this case, a pipeline easement was executed on November 28th, 2012 by Nancy Wheeler and Lee Wheeler to DCP. This easement was executed as part of a settlement in a condemnation suit brought by DCP. Clifton Wheeler passed away in 2012, and we think the record shows that San Miguel knew of his passing in at least 2015. Further, the record shows that from 2011 forward, San Miguel dealt with Nancy Wheeler and Lee Wheeler instead of Clifton Wheeler on this property. In 2014, for the first time, San Miguel filed a permit with the Railroad Commission to mine the property for coal and lignite. That is important because the filing of a permit removes the administrative restraint on mining coal. That was the first time that any steps had been taken, in our opinion, to effectively put this property in mining, and no mining ever occurred prior to that time. In 2016, and in the 2014 permit, Clifton Wheeler was shown as the owner of the property, the surface, and a third of the minerals. In 2016, the permit was amended, showing Nancy Wheeler and Lee Wheeler, trustee, as owners of the coal and lignite and surface in this property. Now, it's important to note, and I think Dave Burris testified in the record, that that application has to be made under penalty of perjury. So certainly in at least 2016, San Miguel knew or should have known who the owner of the property was. Now, we have raised various issues on appeal. The first issue is, it is our belief that the court improperly granted a directed verdict on the construction of a partition deed executed in 1986. Now, we all know that there has to be no material fact, and when this court reviews the granting of the summary judgment, they must view the evidence in the light most favorable to the non-movement, which is us. And the court must indulge. Oh, I'm sorry.
I have a question. Yeah, I have a question.
Okay.
You argue that the partition agreement at issue here is ambiguous because it is susceptible to one or more interpretations.
Yes.
Assuming San Miguel's interpretation is one of those two interpretations, or one of the one or more interpretations, what is your reasonable interpretation of this agreement that makes it ambiguous?
I will go through that right now. If you look at the partition deed, which is in volume 11, and it's plaintiff's exhibit 7, or DX exhibits, no, plaintiff's exhibit 7, which is found on 956 of the record.
And by the way, just to make sure, we do have the partition agreement, even though we don't have volume 11.
Okay. It is our belief that the court struggled for a long time with what later became known as the surface destruction test. Prior to developing the surface destruction test for unnamed minerals, the court said that unnamed minerals includes those that are contained in the ordinary and natural meaning test. And then they developed the surface destruction test, and in Reed 1 and in Mosier, the court specifically held that near surface coal and lignite is owned by the surface owner as part of the surface estate. Mosier, of course, is the case that overturned the surface destruction test and went back to the ordinary and natural meaning test. If we look at the partition deed on page 3 of the partition deed, which is 956 in the record, we know that this is a partition of the surface estate. Since the surface estate is owned by the since the near surface coal and lignite is owned by the surface owner, that passed with the surface estate. And the deed provides the parties' desire to partition and exchange the surface estate in the property so that each party will still own the same undivided interest in the oil, gas, and mineral estate. Under Reed 2 and under Mosier, near surface minerals, which are as a matter of law defined in Reed as being within 200 feet of the surface. It is undisputed in this case that the coal and lignite is no deeper than 200 feet. The testimony in the case was it was around 165 feet. We think where you say the same interest in the oil, gas, and mineral estate, the parties still own the same interest in the oil, gas, and mineral estate because the near surface coal is part of the surface estate. And then if you flip over to item 3, which is page 8 of the partition deed, there was accepted from the partition all oil, gas, and other minerals. And then right at the bottom, there is a definition of oil, gas, and other minerals. And we are not disputing that coal and lignite are included in that definition. However, coal and lignite can be at or near the surface, or it can be deeper coal, depending on which property it is on. It is our belief that this deed shows that the parties intended to reserve the deeper coal and lignite, but because the very last sentence of that says, but excluding sand, gravel, caliche, rock, stone, and similar properties considered part of the surface estate. Now, it's important to when trying to read this deed, to look into the mind of the drafter. We know this deed was drafted in '86, shortly after the Mosier decision. And so the drafter or the scrivener of the instrument is trying to say, these people want to reserve, or we know from Reed 2 and from Mosier that near surface coal is owned by the surface owner. So when I partition the surface estate, that would partition the coal. Well,
May I interrupt you, sir?
Yes.
You gave me a lot of information. Let's start with what you're saying is that despite Reed, the case of Reed, which says that the general rule of the surface destruction test is the 200, within 200 feet of the surface, despite that case, what the Wheelers did when they partition, or what the partition agreement does, is it is not clear as to whether everything below 200 was not deeded or not partitioned, and everything above 200 was partitioned. Is that what you're trying to say?
No, what I'm trying to say is well, yes and no. I think I misunderstood your question. since the near surface coal is owned by the surface owner as a matter of law, and that is a statement directly out of Read 2, that it's part
But
of
Read
the,
also says, and excuse me, Read also says that if you apply the general rule, that's correct, unless there's a contrary intention. So is there a contrary intention set forth in the partition agreement? And
that
if
that
so,
is
where is
correct.
it?
And I'm saying there's not, because of the very last sentence that says, or the part that's in paragraph, in parenthesis, but excluding sand, gravel, caliche, rock, stone, and similar mineral properties considered part of the surface estate. Now, the drafter of that instrument could have said, and including near surface coal, but if
Excuse
you
me, Mr.
look
Mayor.
at the definition here, that is the very definition of what Read 2 and Mosier define as belonging to the surface owner.
But excuse me, Mr. McWilliams, I'm looking at the partition agreement, and you will agree with me, will you not, that there is a definition in the partition agreement of what oil, gas, and minerals means. And it says it shall include oil, gas, and minerals of every kind and character, including but not limited to coal and lignite. And then it goes further to say that, well, let me just stop right there. Since it's
I'm
since
sorry.
it specifically defines as including coal and lignite, wouldn't we have to ignore that language to construe it in the manner in which you're asking us to do?
I don't think you have to ignore the language, because it's considered part of the surface estate, and you have near surface coal and you have deep coal and lignite. So the intent of the parties, a reasonable construction is because it's part of the surface estate, number one, it was not part of the reservation. And then secondly, that what the parties were intending is to reserve coal and lignite that is deeper than 200 feet, because the Scrivener knew that it was a near surface mineral. And that's why this very last sentence was, or the last part of that sentence was an exclusion from the definition. What would happen is the near surface coal, although it doesn't say it, it uses the term, and similar mineral properties considered part of the surface estate.
I have another question then. Right before the partition agreement was signed, who owned the coal and lignite right before?
It was owned 1/3 by Charles Wheeler's. It was owned, to answer the question, it was owned by the surface owner. The surface owner at that time was the 3 children of Charles Wheeler owned 1/3. The Clifton Wheeler Jr. owned 1/3, and Evelyn Swenson owned 1/3. But they owned it by virtue of being the owners of the surface,
Exactly.
the near surface coal.
But reading further in the partition agreement, and this is where I have trouble following your argument. It says it is agreed that the ownership of the oil, gas, and mineral shall not be affected by this partition, but shall remain the same after the execution of this partition as it was prior to the execution hereof.
That's exactly right. And we think that is further proof that ours is a reasonable construction, because they talk about the ownership of the oil, gas, and minerals. You have to remember that under Read 2 and under Mosier, near surface coal is a attribute of the surface estate. So you're not changing the ownership of the oil, gas, and mineral estate, because the coal is actually owned by the surface owners. Judge Alvarez?
Yes, so what you're saying is that because there is an exception versus an exclusion, there's a fact issue, and therefore the whole partition agreement is ambiguous.
Well, I wouldn't say the whole partition agreement. I would say,
With relation to the mineral, with
yeah,
relation to the
the
surface
coal,
and,
the near surface coal, I think creates a fact issue as to, was it the party's intention to execute the partition deed to exclude near surface coal and lignite, since it was owned by the surface owner, and have the deep coal and lignite go to the mineral owner. But I think that's a fact issue that needs to be determined by a judge or jury, not on a summary judgment.
okay, thank you.
Thank you. Any other questions?
No, but you may proceed. You've got a couple of more minutes.
Okay. The next thing we have is we would like to address, and I'm going to have to move along rather quickly here, is the payment of delay rentals. If we look at the lease, the original lease, which was DX1 found on page 7 of the record, if you look under item number 4 of the lease, which is actually on page 9 of the lease, it provides that all delay rentals have to be, and royalties shall continue or shall be paid to First National Bank in Pleasanton. So if we start off with the payment of delay rentals, we know that it says it has to be paid at that bank. And then when we flip over to page 11, the only provision in the coal lease dealing with how do you pay delay rentals in the event someone passes away is quoted in our brief. And it says, in the event of death, minority, or other disability, any person entitled to receive rentals hereunder that they desire to pay, it shall be sufficient if they tender it to the bank. Now, we know they had knowledge of Clifton Wheeler's passing. We know the problem is this lease has spanned 3 generations of Wheelers, which is another issue on our Rule 248 motion. But we say they did not properly pay the rentals because they did not pay them to the bank when they didn't know who to pay them, even though they knew Clifton Wheeler was deceased. And I know that they have raised the issue, well, we didn't meet our burden of proof, but we think at least for 2015, 2016, 2017, which is after that we filed a lawsuit and their performance would be told. Judge Mary?
Yes, isn't there though another provision in that lease though that gives an alternate form of payment, and wasn't it in fact sent through that alternate form of payment?
It was made by that. There is an alternate form of payment if you pay the less, if you're going to pay the lessor. But here they knew a lessor had died and was deceased, and the question was who to pay it to. And Dave Burris testified, we follow our lease, and so they did not follow the lease because they never consulted the lease after Clifton Wheeler died to decide, okay, how do we pay these delay rentals? And this is the only provision in the lease that directly addresses what happens if we don't get information on the probate. And that information is basically that they can pay it to the bank, they can pay it to the individuals jointly,
Right.
or they can pay it to the estate. And I
right,
see
thank
my
you.
time's up.
It is. Thank you, Mr. McWilliams. You will have 10 minutes for rebuttal. Ms. Fry, you may.
May it please the court, Melanie Fry for the Appellee, San Miguel Electric Cooperative, Inc. As the court knows and has heard, the Wheelers filed this case in 2017, trying to invalidate San Miguel's lease on the property. San Miguel has a strip mining lease on this property. And the problem is that the Wheelers had granted a pipeline easement to a company called DCP right through the property that they had leased to San Miguel. And so they're naturally trying to invalidate the lease. San Miguel, as you know, countersued for the Wheelers' breach of the lease for granting the pipeline easement. And all of the litigation up through the full jury trial took place down in McMullen County. The Honorable Judge Starbuldrick Bauer was presiding. And she properly granted a summary judgment motion. She granted a Rule 248 motion on issues of law and narrowed the issues for trial. Yes, Justice Alvarez.
Yeah, sorry to interrupt you. I guess we're really aware with the procedure that happened, but I'm more interested in the focus and focusing on Rule 248. Tell us why your motion for a Rule 248 is valid, and why the ruling is valid.
Yes, Your Honor. Rule 248, we know, allows the trial court to determine issues of law before trial, and the Wheelers concede that in their appellant's brief. This is an appropriate tool for a trial judge to determine issues of law before seating the jury. The Rule 248. Yes,
I'm sorry to interrupt because I want you to answer both parts of Judge Alvarez's question, but before we leave the first part, it seems to me that 248, and I'm reading it. I mean, it gives no help in deciding what the evidentiary factors are when it has to be filed. So I guess my question is, before we go to the second part of Judge Alvarez's question, is because we see this very rarely, the 248, it almost seems like a timing rule. You've got to have these pretrial things done before the jury is impaneled, rather than a kind of a substantive tool like a motion for summary judgment or a Rule 91A motion or anything, something that's dispositive to the jurisdiction. It's more like it's telling us these pretrial matters need to be done as far as practical before the trial commences, rather than an actual vehicle like a summary judgment and that sort of thing. So I'm just lobbing on to the first part of Judge Alvarez's question, and I'm sorry about that, Judge Alvarez. So go ahead, Ms. Fry, and then we'll circle back to Judge Alvarez's.
That was my question.
Sure. So Rule 248 as a rule of civil procedure and as a procedural mechanism to be used before trial. First of all, I will say that 10 days before the jury trial started, the Wheelers amended their petition to add some one-sentence arguments complaining about San Miguel having waited an unreasonable amount of time to develop the lease. Their argument was really, this is a no-term lease and we don't think that's fair. We think this lease ought to have a term, it ought to have a date certain by which the lease has to be developed, and the jury ought to get to decide what a reasonable amount of time is. So that's the argument they're making. The problem is that question for the jury of what a reasonable time is, we don't even get there because binding Texas Supreme Court precedent says no term leases just like this one are valid. And so it would have been a waste of the jury's time and of the court's time to have that heard. As far as the procedural mechanism of 248, I would point the court to Mickens versus Longhorn. The site is 264 Southwest 3rd, 875. Mickens is a 2008 case. It's the Dallas Court of Appeals. And in that case, the Mickensons contended that summary disposition of their claims violated their right to due process. They were making this same argument that the court's questions have touched on. Well, this seems more like a summary judgment procedure. And the court says Texas Rule Civil Procedure 248 directs the trial court to resolve pending matters as far as practicable before a jury trial commences. And that court said that whether a contract is legally enforceable is a question of law for the court, not a fact question for the jury. And that's the procedural posture of the 248. We have the Wheelers saying, well, the jury ought to get to decide what a reasonable amount of time is. And we have Texas Supreme Court precedent that was binding on the trial court that says these no-term leases with an almost identical provision, an almost identical waiver of the implied covenant to reasonably develop, those are valid. They just are. They're valid in Texas. If that's the case, then it would be a waste of time to put it before the jury. In fact, in the argument on the record on the 248 motion, counsel for the Wheelers said, well, you know, we intend to challenge this to the Texas Supreme Court and say that that shouldn't be the law. Well, they're conceding, therefore, that that is the law, and it was the law that the trial court was bound by. So the trial court was absolutely appropriate in a 248 posture in saying, binding Texas Supreme Court precedent answers this question. This is not a question of fact for the jury. I can construe a no-term lease and say it's not invalid for being a no-term lease, and I'm not going to let those theories go to the jury. So we think it was an appropriate procedural vehicle, especially given that we have some kind of new allegations 10 days before trial.
So I guess the question now is, okay, you've got Rule 248, but what type of evidence or how should the evidence be presented, or does the court take judicial notice of the evidence? In other words, what's the mechanism? It doesn't tell you, the rule doesn't tell you. And so here we're missing, in the hearing, we're missing the partition agreement that is the basis of the rule, of the ruling based on the rule.
Sure. So, you know, similar to, let's say, a summary judgment procedure in Rule 166, also not evidentiary, in that you have a hearing, you can't put on live testimony, you can't put in evidence. It's just what's attached. It's what's attached to your pleadings. You know, again, a couple days out from trial, we're at a pre-trial conference, right? And the judge has in front of her actually the trial exhibits, what's about to be admitted. The parties are discussing motions in limine. They're discussing a number of pretrial matters. So these exhibits are absolutely in front of the trial court. Our Rule 248 motion was a written motion in the record. It's found at the clerk's record at 529. And so it was filed and the court had a full hearing on it. And again, the allegation by the Wheelers was, well, it's just inequity, these no-term leases, it just doesn't seem right. And we ought to be able to impose a deadline for San Miguel to develop this land. And the Texas Supreme Court has said, no, they are equitable. We enforce no-term leases. And so all the judge needed was the Supreme Court precedent that we put in front of her. And obviously she had the lease, the no-term lease that she could see, and say, this precludes theories that San Miguel waited too long, that this no-term lease is invalid. And so, based on that record, we think, a 248 motion was absolutely appropriate.
Again, you're saying that the judge made rulings based on what she had in front of her, but it was not admitted for purposes of the 248 hearing. That's the problem that I'm having with the evidence submitted to the judge in order for her to rule in a 248.
I guess my answer would be that the lease was in front of the judge. For any ruling on a question of law, similar to a summary judgment procedure, it wouldn't be proper to admit evidence. It would just be the court looking at, the documents in front of her and the controlling case law to decide that as a matter of law, in other words, the fact that this was a no-term lease is undisputed. The Wheelers aren't going to say, it was a term lease, right? Their theories are it is a no-term lease. So the pleading itself says this no-term lease should not be valid. What we put in front of the court was the binding Texas Supreme Court's precedent saying this kind of lease, a no-term lease, is valid in Texas. And so the court could take that and say, okay, well then theories to the, talking to the jury about how a no-term lease should not be valid, I'm going to preclude those. And that's what she precluded in front of the jury. Yes, Your Honor.
So at the hearing on the 248, dealing with this particular issue, was there any objection to the court looking at the lease? And I mean, what kind of discussion was there? Was there any objection to proceeding with the motion under 248? What transpired there? And what needed to transpire?
I believe that Mr. McWilliams did say that that he felt like, that this was a summary judgment against him, and had a complaint about responding to a Rule 248 motion. There was no objection to the court considering the lease or considering the terms of the no-term lease. Again, we're at pretrial by this point. The lease is marked as an exhibit. We're down to the point of talking about motions in limine. The lease has been put before the court many times before in things filed with the court, including the summary judgment motion. And so there was no objection to the court considering the terms of the no-term lease. Your Honors, to go back to the argument that took up the majority of the court's attention in the first part of today's oral argument regarding the partition deed, Your Honors asked some questions about asking the Wheelers to articulate what the ambiguity is in the partition agreement. And the answer was, well, you need to superimpose this judicially created doctrine, the surface destruction test, to create ambiguity in the plain language of the partition deed. And we would respond that that is absolutely improper. The surface destruction test, first of all, does not apply here. As you point out, Justice Alvarez, it doesn't apply when there's a contrary intention expressed in the partition agreement. Here, there certainly is. The parties, the private parties to this private agreement are saying lignite is a mineral. Lignite, oil, gas, and other minerals means lignite. And that the ownership of lignite doesn't change. It's the same before and after. There's no conveyance made here. And so the surface destruction test simply doesn't apply because our document does expressly define lignite. Those cases developing the surface destruction test, it is very clear that the term oil, gas, and other minerals was undefined. And the court in each one of those cases, in Reed and Acker v. Gwynn, they say, unless there's a contrary indication in the document itself. Yes, Justice Alvarez.
I've got a question. What does the partition agreement have anything to do with the payments, the rental payments? I understand that they want to, the Wheelers or Nancy Wheeler wants to make sure that that she gets the notice versus her father. But what does the partition agreement have to do with it? We don't even have to, this is what I'm thinking, we don't even have to look at the partition agreement to determine whether there's delayed payments based on the lease, right?
I absolutely agree. I think when the court was looking at the directed verdict on the delay rental payments issue, right, the Wheelers claim that went to the jury trial that we had not paid delay rentals properly, the judge was looking at two things. One, she was saying the Wheelers have not put on any evidence that delay rentals were not paid. And this is their claim that they have the burden of proof on, and there was no evidence that they weren't paid. Secondly, the judge had in front of her conclusive evidence as to how they'd been paid. It's Exhibit 5 in the reporter's record. It detailed the payments that had been made from 1978 up to the present. And so the judge had uncontroverted, conclusive evidence about how the delay rentals were paid. And then she also had the plain terms of the lease in front of her. And the lease talking about if there's a change in ownership, then the specific documentation that has to be provided to San Miguel in order to affect a change in who gets the delay rentals. And there was testimony from Mr. Wheeler himself on the stand that documentation was never provided, confirmed from Nancy Wheeler Plumley as well. That documentation was not provided to San Miguel. And the judge is looking at it and saying, and I think, Chief Justice, that you brought this up, there's this provision about how these delay rentals should be paid, and that's how San Miguel is doing it. This is a directed verdict. There's nothing else. There's nothing to go to the jury. There's no contrary evidence about how the delay rentals were paid. To answer your question, Justice Alvarez, regarding what does the partition agreement have to do with it, it's a good one because you really have two separate documents. You've got the lease between San Miguel and the Wheelers talking about mining lignite and how delay rentals should be paid. And then you've got the partition agreement, which is, so the lease is 1954. You've got the partition agreement, 1986. So 30 years later, private agreement between and amongst the members of the Wheeler family. They're deciding in that agreement to simply partition the surface. We submit it could not be more clear that they intended not to convey lignite, that lignite is defined for that family's purpose as a mineral, that the ownership ought to remain a third, a third, a third, the way it was before. And after the partition agreement, a third, a third, a third. And a third is how San Miguel paid the delay rentals. That's how they paid. So if there's any, Your Honor's question was, what does it have to do with it? The Wheelers are trying to say, they're trying to invalidate the lease. They're trying to invalidate the lease. The way they're trying to do that is they're trying to say, they have this tactic to say that San Miguel didn't pay delay rentals to the right family members in the right percentages. And then the Wheelers say, see, the partition deed changed those percentages and San Miguel should have paid them differently. There are numerous problems with that. One, as we've walked through, we know the partition agreement doesn't say that. In fact, it says lignite is accepted from this partition. It says there is no conveyance being made. So we know the plain language of the partition agreement. But moreover, Nancy and Mrs. Nancy Wheeler Pumley and Lee Wheeler in trial testified, no, we actually don't know what the percentages of ownership were. We didn't tell San Miguel what the ownership percentages were. We're just saying you did it wrong because now in litigation in 2017, for the first time, we say we own 100% of it. We shouldn't have just gotten a third. We should have gotten 100% of it, even though for over 30 years, they had accepted a third with no complaint. And that evidence is in the record as well, that 7 months after the partition deed, we have communication from the executrix saying, and this is the executrix of the grandparents' estate of Clifton and Nora, giving instructions to San Miguel that it was a third, a third, a third. In 1989, we've got counsel for the Wheelers, Mr. McWilliams, sending checks to San Miguel saying it's a third, a third, a third. What we've got is, for the first time in litigation, the Wheelers claiming, oh, we own 100%, you did it wrong, so invalidate the lease. That is not supported by the petition agreement. Yes, Your Honor.
Well, I guess then it seems to me that perhaps the real issue in this case is whether or not this lease that, is well over 60 years old, that says to continue with the lease, all San Miguel or its predecessor has to do is pay the delay rentals or mine. So in this case, San Miguel and its predecessor waited 55, 60 years to say, I'm going to mine. They've been paying the rentals according to the trial court and the judgment in this case. So I guess the real issue is one for another day, perhaps a higher court, as to whether or not these kinds of 3 generations of leases is going to remain valid in Texas. Would you agree with that? I mean,
I think the Texas Supreme Court has answered it by saying a no-term lignite lease, a lignite lease like this one, is valid. So I think they have in the Cleghorn opinion. But the other answer to your Honor's question, because I think you raise a good point, this is a lignite lease, not an oil and gas lease. It takes decades and hundreds of millions of dollars to develop this lease. It is a long lead enterprise. This involved environmental, archaeological, anthropological, aerial studies, floodplain studies, dozens of holes and cores drilled out of the earth. They had to construct a highway overpass in order to prepare for the mining. It takes decades and millions of dollars. A lignite lease is unique in that sense from an oil and gas lease. And the Texas Supreme Court, in looking at lignite leases, has said a no-term lignite lease that is perpetuated by the payment of delay rentals is valid. And so I'm confident that they'll continue to uphold that because of the unique nature of a lignite lease. The equipment used to do a lignite lease is massive, and it just takes a lot of money and a lot of time to mine this land. Thank
Any
you.
other questions, Your Honors? All right, thank you very much, Ms.
Thank you.
And Mr. McWilliams, you will have 10 minutes for rebuttal.
Well, I hope I can finish in 10. I think Judge Alvarez asked a good question in how does this partition agreement affect the delay rentals? That's one of the cruxes of the opinion as to whether the delay rentals were paid properly. If we are correct in our interpretation, or if it's ambiguous, it is possible that Clifton Charles Wheeler Jr. should have been paid 100% of the delay rentals rather than the directions given by the executor. What I find interesting in this case, and I do some oil and gas, is that nowhere, and I think the testimony is disputed, did Clifton Charles Wheeler say anything that he was only entitled to 1/3 of these delay rentals. And we see in the record that Mrs. Fry, where the executor said, okay, pay the delay rentals this way. And they did that, but we never agreed to that. There doesn't seem to be any documents to be furnished. What duty is owed by this coal company to make sure that it's correct? Now, I also would like to address the Rule 248 motion. And quite frankly, I was a little surprised. I received the motion the morning of the hearing, and it just seems blatantly unfair to me that the court can grant something by reading a piece of paper without hearing any evidence or receiving any evidence. Now, the lease was, in my recollection, never in front of the judge. Ms. Fry said it was in front of the judge at the summary judgment hearing, but the summary judgment was limited solely to construction of the lease.
Sure.
Yes, ma'am.
And I agree with you that the lease was not, at least in front of the judge for purposes of this motion, and at least we didn't find it. But didn't you waive that argument? You didn't object to it?
We heard the motion, but we filed we might have waived it the morning of trial, but by filing, it's my opinion, by filing a motion for new trial, we raised that point and gave the trial judge a chance to correct her error in which we think were numerous errors in this. Now, and I'm having a hard time reading my notes, but we think also that the Weed case and the Dallas Power and Light case, those cases can be distinguished because the length of time in those cases was substantially shorter than the 20 years we have here. And I don't think there's any evidence in the record that it takes, these almost generations to mine coal and lignite. I mean, it is different than oil and gas and takes some time to mine. but it doesn't take generations. And I would remind the court that in 1923, and I was not born there, but luckily the good Lord at that time, but the good Lord gave me the ability to read. And I found it in my research in a case, Texas Company versus Davis, and it's in my brief. And it cited with approval a North Carolina court that had a 99-year, that discussed a 99-year gold lease. And the decision from 1923 said it would be unjust and unreasonable and contravene the nature and spirit of the lease to allow the lessee to continue to hold his term a considerable length of time without making any effort at all to mine for gold or other minerals. Such a construction of the rights of the parties would enable him to prevent the lessor from getting his tolls under the express covenant to pay the same, and deprive him of all opportunity to work the mine himself or permit others to do so. And the quote that will live with me forever: the law does not tolerate such practical absurdity, nor will it permit the possibility of such injustice. And we think that's almost over 100 years ago. Our forefathers recognized that we can't allow these things to go on as a matter of public policy.
But you agree, Mr. Beck-Williams, that that issue is not for this court to determine, correct?
Well,
I mean, you agree that the Supreme Court has already weighed in on this particular.
The Supreme Court has weighed in on it. If you wanted to be bold and adventuresome in this age, I guess you could weigh in on it.
Well, let's go back to the Rule 248 issue. It seems to me, and there was extensive discussion before the jury was impaneled about the lease and in connection with the motion, the 248 motion. So why is that not then preserved? It seems like that y'all were talking about the lease provisions, and everybody knew what the lease provisions were. They were there before the court, marked as an exhibit. Why? I just want to hear your point about whether or not that was preserved or whether it was waived. Your objections.
I don't think we waived our objection. Because we argued the case and we filed our motion for new trial on that very issue. I think the record is quite clear that the court was gonna do it. So, but we don't think it was waived, and certainly if we waived it, any waiver was cured by our motion for new trial on that, and the judge should have granted that issue. Any other?
I don't have any other questions, but you have a couple of minutes if you'd like to wrap it up.
Well, we think that the court in this case, I noticed that on the note, that we had some points we didn't cover in our brief, and we think that Appellee breached the contract because that in their brief they say we didn't have any contractual relationship with them, and we found that odd because it seemed at conflict when they sought damages. I don't know how a surface owner who signs a lease and provides for no warranty of title and signs the pipeline easement in condemnation can get sued when the pipeline company decides the route of the pipeline to go that it's gonna go through and then San Miguel sues us and gets a judgment for $16,000. We just, that's just inconceivable to me. But I will yield the balance of my time. Unless you have any questions.
Any other questions? All right, well, thank you both very much for your arguments. The case has been submitted and court will be adjourned. Thank you very much.
Thank you.